Ah yes, the naturalization termination request. You're right to be concerned about these new temporary judges. This is one of the trickiest motions to make. We both know that under 8 CFR sections 1003.1m and 1003.18d, in theory, you can move for discretionary termination when your client is prima facie eligible for naturalization. OPLA must not affirmatively oppose, and the agency likely will. Even with the most compelling factors, OPLA likely will not agree. File this as a written motion, always. Check the Federal Register commentary at the bottom of your 8 CFR citation. It explains the regulation's intent. You're concerned about futility? Valid. But not trying could be malpractice. Document everything. Make your record. Here's an alternative strategy. File the N-400 directly with USCIS. Yes, during removal proceedings. The USCIS website lists N-400 as non-discretionary. After Patel v. Garland, courts can't review discretionary decisions, but non-discretionary applications? Different territory. Look at Calvo v. Garcia, a Northern District of Texas case. It holds USCIS has jurisdiction over naturalization during removal proceedings in some circumstances. That contradicts what the IJ and DHS will argue, and it contradicts what USCIS says on its website. You'll need to fight this in district court. But without it, your client with that cocaine conviction faces permanent removal. At least give your client the option, and put it in writing to protect yourself from a future malpractice or Losada claim. And note the circuit split on the naturalization during removal proceedings. The Second Circuit never addressed the Calvo issues and opposes naturalization while in removal proceedings. The Ninth Circuit supports naturalization while in removal proceedings. That case is Yith, Y-I-T-H. Review both cases, and Calvo gives a good summary of the circuit court decisions. My recommendation? Seek termination under 1003.18d, absolutely, but simultaneously submit the N-400 to USCIS, knowing that you'll end up in district court. When USCIS stalls, you have mandamus grounds. The non-discretionary nature gives you the federal court avenue Patel didn't close. Document meticulously and explain in writing to your client, even if you think your client cannot afford the lawsuit. Explaining what could have been done after removal order to your client or their new attorney. That's not a conversation you want.